the music panel in about a minute. Thanks everyone for staying. Hope you enjoyed the program so far, and we'll have a great music panel coming up. So hope you enjoyed as well. So I'd like to just quickly introduce Professor Lang, and then he's going to give a brief introduction for the music panel this afternoon. Thank you.
Thank you, Zhang, and thanks to all who have come for this afternoon's session. I think this is probably what patent lawyers would call a continuation in part proceeding. In any event, it is a continuation, but a shift to a different subject. This is the afternoon panel on the music industry and the issues that are facing it, or some of the issues that are facing it, and it is a great pleasure to welcome what is truly a distinguished panel. Beginning on this end, just to go down in order, Stephen Marks, who is General Counsel to the RIAA, and who, I should say, in order to warn you, the schedule of their presentations has been changed so that I think no one is actually speaking in the order in which he was originally assigned. This because of the nature of their remarks made it seem that it would be useful to present them in a slightly different order. But we will begin with Stephen, who will speak generally about the things that have happened to the recording industry that bring us to the point at which it is sensible to speak of the music industry now as a hot topic. We will then hear from James Trigg, who is a partner at Kilpatrick Stockton in Atlanta and himself a professional musician. And I don't mean just a teeny professional musician, but a genuine, full-fledged professional musician who really quite sensibly could have remained one, but chose instead to assume the austere and monkish robes of a practicing lawyer. And then we have Jason Schultz from the Electronic Frontier Foundation, who will actually speak last today in a kind of cleanup position. I mean nothing substantive by that term. I'm only thinking that as spring approaches, so does baseball, and he will assume the position of a cleanup hitter. His remarks, which will be last in order, will, in some sense, be arrayed against the thrust of the remarks that have gone before. Actually, our third speaker will be Bertis Downs, who is sitting fourth along the row in the panel. Bertis is, he doesn't like for me to say it, I think, because I think he thinks it suggests that he's older than he is. I have referred to him as the eminence grise of REM, but perhaps I should say instead that he is general counsel to REM, and he is, I would say, the Brian Epstein of REM, except that he's still alive. And finally, speaking fourth, but sitting fifth, is Jim Berger, who is a partner at Lohnes and Albertson in Washington, whose background is in the IT area, and who, like Jason, sees the issues that we are discussing this afternoon in some respects that amount to a departure from the things that I think will be thought and presented by the first three speakers. So, having done all that I need to do, and indeed perhaps a little more, I'll begin by turning the speaker's podium over to Stephen Marks, who is Executive Vice President, General Counsel of the Recording Industry Association of America. Thanks.
Thought I was going to get the opening and the closing. Apparently not. What I'm going to do today is not focus on any specific legal case, but to try and go through a little bit about what the recording industry is, who the players are, what the economics are, what the challenges are that we're facing, what's happened over the past year, not just legally, but in terms of impact culturally, I do think it'll be a good setup, as Professor Lang said, for some of the discussion to follow. So I thought we would start with a little interactive test, since this is my first time back at law school for a while. You can hit the little button there. We can, not too loud, but Can you get it there? We have to have music in this presentation, so. Will it click? Won't go? We have, we're supposed to, yeah, anything that's not licensed automatically doesn't play. All right, well, this is the first and last time you'll hear me say that this is a fair use, so. It's supposed to play the Price is Right music, but I guess we'll have to go without it. So I wanted to put up a few things on the screen, and maybe you all can jot down on your own, and then we can see who got the order right of the cost or the dollars for each of these. So first we've got royalties that are paid by an internet radio site for streaming a song to 1,000 listeners, and that's royalties paid to the record company and the artists. Then we have the songwriter royalty for one song that's downloaded 100 times on iTunes. Third, royalties paid to copyright owners for each sale of an iPod. Fourth, the average artist royalties paid by over-the-air radio per song. And then a Duke Spirit band bracelet and Duke shot glass. I figured I'd throw the shot glass in at least for all the students in the audience. There's still know where to place that one. So the music would normally be playing now, so I'll give you like 20 seconds to try and jot down on your own what they are, and then for the fun of it, we can go through it. So, anybody want to hum the tune while we're doing this? Huh? Yeah. Yeah, I think there's a site license for the university, so we'd be okay. All right, so let's see what the answer is. The average artist royalties paid by terrestrial radio. As we'll talk about in a little bit, over-the-air radio pays nothing to record companies and artists for the copyrighted sound recording. They only pay royalties to songwriters. Royalties paid to copyright owners for each sale of an iPod is also zero. There are no royalties that are paid. While there are some royalties on devices under the Audio Home Recording Act, the iPod is not a device that would qualify under that act. Royalties paid by an internet radio site for streaming a song to 1,000 listeners. They pay 0.07 cents per song streamed, so that adds up to 70 cents. The Duke Spirit band bracelet is $2. The shot glass is $6. And then last, you have $8.50. It's actually now up to $9.10 for every song that's downloaded 100 times on iTunes as the royalties paid to the songwriter. Anybody get them all in order? Anybody come close? All right. Let's talk a little bit about who the players are and what the revenue streams are. The most basic thing to understand when it comes to music that a lot of people don't realize is that there are two copyrighted works in music. The first is called the musical composition or the musical work, and that is essentially the song as you would see it on a piece of paper, the notes and lyrics as written by the songwriter. And then the second is the sound recording, which is the fixation of those musical sounds, the song, onto some kind of tangible medium, such as a CD. Now, the reason this is important, as we'll go through, is that there are different owners for the different copyrighted works and different rights and revenue streams for each one. And so as we were just talking about performance rights, the songwriter of a song gets paid performance rights by an over-the-air radio station, but the artist and the record company that produced and created the actual recording doesn't. In terms of the musical work, it's the songwriter who usually enters into a contract with a music publisher who gets an interest in the song in exchange for certain services. Traditionally, publishers played a very important creative role in musical works because they were the promoters and the exploiters of the musical work. Think of plugging songs on Tin Pan Alley a long time ago. They would essentially be the ones that found the songwriters and got the songs played live in a theater or produced on sheet music to sell. Today, the record labels generally play the role of finding and developing talent. Music publishers still find and sign talent sometimes, but often do that signing after the record label has signed a band, for example, for singer-songwriters, so that the risk is much less to the music publisher than it is to the label. The sound recordings are generally owned by a record company through a contract with artists and producers and background musicians, and they're through recording contracts that where there's an exclusive contract to record over a certain period of time or for a certain number of albums. Record companies, as I said, generally perform the creative role that publishers perform. Now, this is kind of a chart just to give you a feel of where the money comes from for those that are in the creative and distribution process for music. Down here you've got record labels, songwriters / publishers, artists, and retailers, and then 4 basic categories, and we'll talk a little bit more about how these categories and business models are changing. But if you look, you can see that the labels derive revenue essentially only from sales. There is a very limited public performance right now for digital transmissions that they also receive royalties from, but it's a very small portion. Songwriters and music publishers have both performance royalties and sales royalties. Artists have it from in 3 categories, and if the artist is the songwriter, they would have all 4 categories, and then the retailers are essentially in the same position as the record label. So as we go through and talk about some of the things about the challenges that have been facing the industry as a result of piracy, you can get a feel for which of these creators and distributors is affected most by piracy. With regard to performance rights, China and Singapore are the only other industrial countries that don't have a public performance right. Stated another way, in terms of countries that have copyright laws that are sophisticated like the U.S., the U.S. really is the only country that doesn't have a public performance right for producers. In Europe, they have what are called neighboring rights, which are close, not exactly a copyright, but there is compensation for performances there. So you're in a very unique position here if you're an artist or a record label, and especially a record label where you essentially have one stream of revenue traditionally, and that's from sales. So when that stream of revenue is affected, you don't have other revenue streams to fall back on. You could compare it, for example, to the movie industry as well, where you have different, studios have different windows and different opportunities, therefore, to derive revenues. And if one of them is affected, they can fall back on others. There's also a considerable amount of money that's not paid to U.S. Labels and artists because we don't have a right here, and therefore there's no reciprocal right, and there's no payment that are made for the playing of U.S. works, which predominate in a lot of countries. Here's kind of an overview of label economics. I mean, you have essentially an investment in music that goes toward finding artists, producing, marketing, and distributing the works. That's supposed to derive revenues and profits, much of which goes back into the investments for the next artist. We kind of did this as a colander to demonstrate that you've got a lot of seepage as a result of piracy. So this kind of captures, at least from our viewpoint, what's happening. You have an investment, and before you get to the revenues, things are falling through the cracks, and therefore the revenues are down, the profits are down, and the resulting investment of music is down, where you have artist rosters being slashed and songwriters out of work. Record companies are in a very high-risk business. Very few albums are successful. 45,000 a year are put out. 58% of them sell less than 100 copies. Probably, some percentage of those deserve to sell less than 100 copies, but 80% of them sell less than 1,000, and you've got 80% of all album sales derived from 700 titles. So you can see this this is a very hit-driven business. I mean, it's the equivalent of trying to hit the gusher out in the oil fields. And as a general rule, 90% of all releases lose money. That's kind of the break-even point. In terms of looking at it with regard to artists, only 5% of artists have a hit. There is a large upfront investment for every artist that doesn't have a hit. This is based on data collected from 91 to 2001, a study that was done. And then even when artists are successful, there's a limit to the upside, because the way the business works today is that very few artists stay long-term with their labels, and virtually every artist, as soon as they have a hit, renegotiate for higher compensation. The label's in the position of potentially, you've got a very odd situation here, because the artist is in complete control of the delivery of the product, and therefore in that bargaining relationship, if the artist doesn't produce the record, which obviously has an effect on the artist's career as well, the label can't derive the benefit of the investment that it's made from that next record. Here's just a graphic chart showing the decline in sales and shipments. You can see that after 1999, you had a plummet of 30%. It's kind of leveled off in 04 and down a little bit in 05 from 04. And this is maybe even a more significant chart. Because the business is hit-driven, record labels depend on the most successful albums to pay for the investment in all of the other artists. And what's happened is that the number of albums that were in the top 10, if you just take a look at the top-selling albums in a given year, have declined precipitously from previous levels. So when you get that hit, and you're supposed to be deriving, and labels had become accustomed to deriving a certain amount of income to then pay for other artists' investments, that now has fallen considerably. So 60 million albums in 2000, and much lower over the past 4 or 5 years. So what role do we play? Well, this we thought pretty much sums it up for a lot of people. I don't think most people know who we are and what we do. We've obviously been on the forefront of litigation, both against individual services like Napster and Grokster, as well as lawsuits against individuals to help in the effort to deal with the piracy problems. It's a great, you can just sit and look at that for a while, it'd be good. The issue is really, it's permeated the culture at a number of levels. I mean, you had this Letterman top 10 asked by Hussein when he was captured. I like actually number 8 the best. Anyone have a mint? But the fact that we're in the list shows how this issue has become part of the culture, and hopefully this will work. Why isn't Jay playing? Wait, we gotta get Jay to play. Hold on, let's see if we can get this guy. All right, well, not, huh? Yeah, anyway, he had a funny bit as well. Here's another cartoon. Finally found bin Laden when the record industry lawyers got him for illegally downloading files. More seriously, artists have been a very big part of being vocal about downloading legally. And these are just some ads that various artists have placed over time. Then you hit last June, and we had the Supreme Court decision, obviously, in the Grokster case. A series of rulings abroad that similarly ruled favorably for the recording industry. Australia was the Kazaa decision, finding that Kazaa was illegal. And you've begun to see unlicensed P2Ps begin either ceasing operations or begin discussing conversion. So You know, we've kind of gone from just jokes about it to a cultural change where you see advertisements about, you know, it's not cool to steal music anymore, and things in Glamour magazine about starting to pay for songs you've been downloading. So it's kind of permeating the culture in a different way. Here's just a list of, boy, do I have to do this one by one? A list of all the different services that are now out there. So, you know, there have been a lot of criticism about record labels not launching legitimate services at the time that a lot of the P2P activity began, but I don't think that can be said any longer. So we can get into, obviously, and I know others will, specifics about the Grokster case and some of the lawsuits in the discussion section. But I wanted to talk about a couple of challenges and how you know, models are changing. This is one of my favorite charts to show about the industry. What you have here is, on this side, number of units and historically on the bottom in terms of years and what's happened in the industry. And then each different color represents a different format. And so what you see is, you know, over time, a gradual increase in terms of sales, popularity of music, and one format taking over for the other, you know, LP to cassette to CDs, and each one of them, you know, reaching a peak and then declining and then some other format taking over. Well, if you look at the end, you know, right now, it's my own view that what's going to happen on the end is that you're not going to see one dominant format taking over like you have for, you know, historically, but you're going to see kind of a stack of different revenue streams 3 or 5 years out. Sales, physical sales, different kinds of physical products, things like, you know, dual disc or maybe the HD, DVD, Blu-ray kind of discs for audio with video content, digital download subscription services, mobile products like ringtunes. It's a very different business for us going forward than it has been traditionally. And, you know, there are already new you know, revenue models that are being explored, and, you know, some are redoing deals with artists or entering into new kinds of deals with artists where there is a participation in the artist tour and merchandising revenues that the label gets in exchange for an investment up front. Music videos, which were traditionally promotional, are now part of subscription and other services that are available on the internet. Product placement, like all products, is now becoming a big issue. And if you think about the enjoying music right now, you've got kind of a continuum. You know, traditionally you kind of had the first and the last, but nothing in the middle. Now you've got radio, internet and satellite radio, which is different because it provides services without commercials, but that are very highly themed genre stations. Then you've got customized radio where things are personalized for an individual, tethered downloads for on-demand subscription services like a Napster or Rhapsody, having those subscription services be portable, and then you've got permanent ownership like on a disc or a digital download. One thing that we face as a challenge because of the different rights that you have in terms of radio versus downloads and what kind of licenses is to have some kind of parity, because you essentially have a convergence across different platforms where the end product to the consumer, to the user, is very similar, but the licensing and the rights issues are very different. For example, just looking at, you've got over-the-air radio, they pay nothing in royalties and have absolutely no content protection obligations. Satellite radio pays something to us under the limited public performance right, but it's under a compulsory license and they pay below market rates. Webcast are similarly a compulsory license, a better rate standard for us, but still not a market. And then you have on-demand subscription and download services where they must go into the market and obtain a license. As I was saying, little distinction for consumers. If you look across different kinds of devices that are either in the market or will be in the market, you have things that allow people to receive and have a library on them. So they're all kind of personalized and portable devices, whether things for digital radio, for example, where you're going to have devices that are available that allow you not only to receive the signal, but to scan for specific artists or songs, to catalog them as a library. This is a problem when you've got no royalties being paid by radio, and that kind of service would be competing with something like an iTunes or an on-demand subscription service. And you can look at some of the things. This is a quote from somebody who had the S50, which is the Sirius device. This device is great. I'm putting my iPod in mothballs. No more downloading, no more 99 cents a tune, no more searching for tunes in the genre I like. I subscribe to Sirius. I have a device that can record all the songs. I can build a library from the songs that I like, and I don't need to buy the music anymore. Those devices are fine. They're great so long as we've got the same kind of marketplace licenses that are being obtained. XM itself, takes aim at the iPod by saying it's not the iPod, it's the mothership for its device. The other problem we face is publishing licenses. I'll go through this before you fall asleep in 20 seconds because this is a very dry area. But basically, the musical works are generally licensed under a compulsory license. The license is very complicated because it requires separate licensing for each writer that's part of any specific work on a CD. So you can have an album that would require 100 separate licenses, and then you have to go and get licenses over and over for each new format. So once you've done it to put it out on a CD, you have to go out and get the licenses again if you want to put the music out as a digital download. And then you've got different organizations representing publishers that are requiring payments for a single use. An on-demand subscription service, for example, they're claiming, well, we should get paid because they're performances, but we should also get paid because they're the equivalent of a sale because they're on demand. And so you have two separate organizations, each putting money into a different pocket of the same pair of pants. And it's causing a tremendous problem for launching new products. So the only thing I had left was a little David Spade bit, but we can't get the audio to work, and my time's up anyway, so maybe if we can get it to work, we can do it later. Thanks.
I really feel that I owe Stephen an apology, two apologies, I think. I had neglected to mention that he is a graduate of Duke, not once but twice, and I wanted to acknowledge that and thank him for staying with us. I also meant to quite seriously observe that he's been named one of 50 best in-house counsel in the United States quite recently, which I think is a distinction that does seriously deserve a mention. The second apology is a somewhat different order. I do apologize for our IT department's inability to get your entire program up and running on the audio side. I have a hunch, I don't know this, I'll inquire later, that it may be that they inadvertently downloaded a virus when they were fulfilling my order for Tom Waits music. But we'll look into that and see what we find after the program is over. James Trigg is a professional musician who could easily have remained one. He's that good and continues to play professionally. He's also a partner at Kilpatrick Stockton in Atlanta, where he specializes particularly in copyright, but also in trademark law, working with two of the Kilpatrick Stockton lawyers who are, I think, really leading figures in those fields in their own right. And I'll bring James on with that introduction. Thank you.
When Steve mentioned the statistic about 58% of albums released last year selling less than 100 copies, the wheels in my head immediately began frantically turning. The band I play with in Atlanta put an album out last spring, and I was wondering, are we within that 58%? I'm happy to report that I think that in December we passed it thanks to a large extended family and a lot of people who owe me favors. So I breathed a sigh of relief. I think we're in the fortunate 42% that have crossed the threshold. I want to say a couple words about myself. I think it's important for you guys to understand a little bit about who I am and what I do, because that informs the angle that I'm going to take on this topic today. I am not a music business lawyer. I am not a technology industry lawyer. I am a copyright and trademark lawyer who advises clients, some of whom happen to be in the music business, some of whom happen to be in the technology field, some of whom are not in either. But I focus my practice on litigating copyright and trademark issues and advising clients on copyright and trademark issues as they try to navigate some of these minefields that we have now in the IP world. The increasing convergence, and I wouldn't even say that, I would say it's not a convergence, I would say that it is now converged. You have a collision, I think, in intellectual property law of two competing values. You have the interests of intellectual property content owners who have legitimate interests in protecting their property, enforcing rights in their property. You have that interest bumping up against the interests of technology companies that want to innovate, that want to come up with new and creative ways of making information available, of distributing content. Those two values live in tension with one another. As an intellectual property lawyer, it makes my job aggravating on one level because the courts are struggling so hard with finding the balance between these competing values that oftentimes the cases are very hard to glean meaningful instruction from. And so it's very difficult for me in my practice oftentimes to give clients very definitive advice on what they should do to be enforcing their rights and what they should be doing to avoid liability. At the same time, along with that aggravation comes just a great deal of intellectual interest because this area is changing so fast. As a lawyer, it's a very stimulating area to practice in and a lot of fun to be working on, even though I can't be as definitive as I would like to be in giving advice. I'm going to talk about a couple cases today that I think nicely illustrate the balancing act that's going on right now. I felt that it was important to have one of the speakers on the panel today give a bit of background about the Grokster decision, sort of how did the Grokster case get to the Supreme Court, what did the Supreme Court actually do when it decided Grokster. Then I want to talk about another interesting recent copyright decision that actually has nothing to do with music law, but again deals with these sort of competing values of content ownership versus content distribution. And I think that these two cases together provide a nice legal backdrop for some of the more business-oriented discussions that you'll be hearing, that you've already heard and that you will be hearing from some of the other speakers. I want to start with a quotation from the Senate report, the legislative history of the Digital Millennium Copyright Act. The DMCA was passed back in the late 1990s, and some of you may be familiar with it. It's a very dense and complicated statute, but in essence, one of the principal things that the DMCA did is it provided an insulation from liability under certain circumstances for internet service providers. In the Senate report, the Senate acknowledged the competing values in play as IP rights and technology rights are converging. The Senate said that due to the ease with which digital works can be copied and distributed worldwide virtually instantaneously, copyright owners will hesitate to make works readily available on the internet without reasonable assurance that they will be protected against massive piracy. Against that sentiment, the Senate recognized, at the same time, without clarification of their liability, service providers may hesitate to make the necessary investment in the expansion of the speed and capacity of the internet. I think that quotation nicely sets up the issues that are in play in virtually all of these new media copyright cases. With that said, moving to Grokster. This case came down last June. It was on appeal from the Ninth Circuit Court of Appeals. Grokster involved a large group of plaintiffs, all of whom were copyright holders. Some of them were holders of music copyrights, some of them were holders of copyrights in audiovisual works. The defendants were two companies that were engaged in the distribution of peer-to-peer file sharing software, which I will briefly explain in just a couple minutes how that works. The district court in Grokster found in favor of the defendants. The Ninth Circuit affirmed the district court's holding. The copyright owners appealed the case to the Supreme Court, and as the Supreme Court commenced its discussion, it started with a quote that on some level echoes the DMCA quote that I put up just a couple minutes ago. The Supreme Court noted that the appellants fault the Court of Appeals holding for upsetting a sound balance between, one, the respective values of supporting creative pursuits through copyright protection, and two, promoting innovation in new communication technologies by limiting the incidence of liability for copyright infringement. The tension between the two values is the subject of this case. Before we get into this opinion, I think that it's important to know a little bit about what the Grokster case was. First of all, what was peer-to-peer file sharing software? Peer-to-peer file sharing software allows an internet user who has that software in their computer to distribute music files, audiovisual files, other kinds of files, and to receive those kinds of files on their computer with other internet users who have the same software. And I'm not a technology expert, but the way that the software works is that it allows this sharing to happen without the transaction having to go through a centralized hub or server, hence the term peer-to-peer. Now, this technology is different than the technology that Napster got into trouble for back in the late 90s, early 2000s. The Napster file sharing software relied upon a central server which facilitated every exchange of information. And the genius of the software distributed by the defendants in the Grokster case was that it eliminated this central hub through which the information had to travel. Now, the issue in the Grokster case was not whether the Grokster defendants were directly engaging in copyright infringement. The only thing that the defendants in Grokster did is they sold a product. And many of the users of those products used the products to download and exchange unauthorized files. The question about liability in the Grokster case was whether the distributors of the software should be secondarily liable for the acts of infringement committed by people using the product. Now, there are two different types, or at least up until the Supreme Court's decision from last June, there were two types of secondary liability in play in copyright law. The first type of secondary liability was known as contributory infringement. One could be liable for contributory infringement if it materially contributed to acts of infringement with knowledge that the infringement was taking place. Second type of secondary liability was called vicarious infringement. One could be vicariously liable for copyright infringement if he or she provided the site and facilities for infringement to take place, having the right and ability to supervise and control the infringement, and at the same time profiting from the infringement. In the Ninth Circuit's opinion in Grokster, it first analyzed the contributory infringement question. Should the Grokster defendants be contributorily liable for the acts of infringement of their customers. The holding was that they were not contributorily liable, and the court looked at the two prongs, knowledge and contribution, and decided that neither of them pointed towards a determination of secondary liability. First of all, the court held that the Grokster defendants did not have sufficient knowledge to render them liable. The court found that because the defendant's software was capable of substantial non-infringing uses, that a higher threshold of knowledge had to be shown by the plaintiff. It wasn't enough that there be constructive or general knowledge that the product might be used to commit infringement. The court looked at a variety of evidence about potential legitimate uses of the defendant's software, found that the product was capable of substantial non-infringing use, and held that the plaintiff had to show that the defendant had actual knowledge of infringement at a time at which the defendant could actually act and do something about it. That was found to be lacking in this case because, again, the way that the software worked is that once the software was downloaded onto the user's computer, basically the egg was scrambled at that point, and the proprietor of the software could no longer do anything to prevent what was done with the software once it was in the user's hands. With respect to the question of contributing, providing a material contribution to the infringement, the Ninth Circuit said that unlike Napster, which again depended upon a centralized hub of a centralized server in order to facilitate the exchange of information, here the defendants were not providing site and facilities for the infringement to take place. Again, all of this happened on a peer-to-peer level. So the Grokster defendants were found not liable for contributory infringement. Moving to the issue of vicarious infringement, the Ninth Circuit looked at, again, the site and facilities question, found that there was no centralized server that facilitated the exchange of information, no liability under the vicarious infringement analysis either. Now, the case gets appealed to the Supreme Court, and everybody, I think, is focusing on how is the Supreme Court going to analyze the issue of contributory liability? How do they analyze the issue of vicarious liability? Well, the Supreme Court kind of throws a curveball. And the Supreme Court, instead of analyzing this under contributory and vicarious analysis, the Supreme Court adds a new theory of secondary liability into the copyright world. They borrow the concept of inducement liability from patent law. And it was an interesting decision because the court actually went back into the record of the Grokster case, focused on a number of facts that you didn't actually see discussed in the district court opinion or in the Ninth Circuit opinion. But there were a number, and I'll just bullet point them here, there were a number of facts in the record that suggested that the Grokster defendants knew how their product was going to be used, and that they intended for their product to primarily be used for the purpose of impermissibly trading copyrighted material. So, casting aside the contributory and vicarious liability questions, the holding of the court was that we hold that one who distributes a device with the object of promoting its use to infringe copyright, as shown by clear expression or other affirmative steps taken to foster infringement, is liable for the resulting acts of infringement by third parties. Interestingly, the court said that knowledge of infringing activity was not necessarily the most important consideration, that a little bit of knowledge about a product being used for infringement would not necessarily subject a defendant to liability under the inducement standard. Now, a couple of critiques of Grokster from the standpoint of a lawyer who has to interpret these cases and advise clients about how to govern their behavior. Grokster undoubtedly did a good job of dealing with finding a way to impose liability upon two defendants that seemed to be up to no good. There are all kinds of bad facts in the record as to how these folks intended for their products to be used. Unfortunately, the court left a lot of open questions with respect to the question of contributory infringement and vicarious infringement. There was a good bit of discussion about those issues in the concurring opinions, but the opinion of the court actually did nothing to clarify those issues whatsoever. And one could query that in the court's extensive discussion of the bad facts that supported the inducement liability theory, has the court basically provided a roadmap for the next company to come along and decide how they can conceal their behavior and adjust their behavior and engage in practices so that they don't create a paper trail about what their intentions and motivations might be, so that they can avoid liability. And I wonder whether within the next 3 to 5 years, we're going to see another case that raises some of these very same issues involving a set of facts that are closer than what the court was dealing with in Grokster. It looks as though I'm bumping up against 15 minutes, so I think I'm going to leave it there. We're going to have a roundtable discussion later on, and we can get into some more of these issues at that time.
Well, some of you know I'm a big college basketball fan, so it's always fun to be I didn't say I was a Duke fan, but I do admire a lot about the Duke program. One of the things that I admire about them is the way their players always have a good sense of game, time, court awareness. And I realize we're going a little long today, and I don't want to deprive you of the real highlights, not that these weren't already coming up. So I'm just going to give you a very short version of mine. My topic is what's a musician to do? An old warhorse's guide to navigating these turbulent times. Shorter Bertis downs. Work on your live show and keep costs down. Thank you very much. I think we're back on schedule now. I will do a truncated version of what I was planning to do because I speak in 50-minute segments, and I thought it was 50 minutes today, and it's just 15. So, and I do call on people too in my class, so I may kind of shake things up a little bit. But I'm also reminded when I come back to Duke of the time that I sat here with a similar. It was a little less sophisticated of a panel. In terms of the personnel, I was on it again, but it wasn't quite as much of an actual production like the Hot Topics panel has evolved into. It was more of a brown bag lunch, kind of more like what we did in your class today. And it was Eric Greenspan from Los Angeles, a Duke undergrad alum, Rick Stryker, who was at the time, I don't think he was general counsel, but he was sort of the number 2 person in the Warner Brothers legal affairs department. And we just decided to kind of get to know our audience and ask people how many of them downloaded music and didn't buy CDs anymore. And basically everybody in the room raised their hand. These are law students at Duke in about '98. It was right around the time Napster was getting started. And I kind of looked over at Rick, and he's now in graduate school, and he's got a very happy life, and he has no real regrets about not being in the music industry anymore. But it was sort of a turning point for our own understanding. Here we are practicing, but we realized something's really going on here, and it's the advent of the world's largest copying machine. Has certainly kind of rocked our world in terms of what musicians and record companies and the equation between musicians, record companies, and consumers is. You can't go back. All we can do is go forward, and what it's becoming. And so that's kind of what I want to address right now. Back when REM was first coming along, music industry was kind of a simple thing. Work hard, build up a fan base, write tons of songs, put out an independent record, tour like crazy, write tons more songs, sign a record deal, keep touring, keep building more fans, grow, mature, develop into a thriving business. That was the basic idea, and for some artists, some of the lucky ones, some of the ones who were at the right place at the right time, it worked pretty well. That was that's my memory, and maybe it's an oversimplified remembrance of the way things were, but it does illustrate the basic building blocks of a successful career as a working musician: touring, recording, building up a market, and signing with a major label. That was kind of not that there were formulas, but that was kind of the way people expected to do it. Despite the rapid changes in technology that we're all well aware of, The more things change, the more things stay the same. The choices are a lot more diverse. The business models of the players in the industry are certainly shifting, if not collapsing. And the consumption in media for music are certainly multiplying before our eyes. But the basic ingredients to a successful music career have not changed that much at all. There's a given, you gotta have quality music. The intangible essential of word of mouth. How do you get people talking about your music? How do you become popular? How do you spread the word so that when you go back to that town, you're playing a bigger place? More people are involved in your career. More people are buying your t-shirts. More people want to have something to do with your career. The ability to monetize some aspect of one's musical output and the need for a team of people, allies, to help focus public attention and marshal support to get the word out. I'm not going to really spend a lot of time because we are all aware and saw on the great PowerPoint that was presented about the statistics, but you kind of know what the music industry is doing. There's the great Wired cover, not great, I don't mean that, Steve, in any personal way, but there's the Wired cover of the dirigible, the Zeppelin, the death of the music business, all the doom and gloom that pervades of the kind of numbers and I do see it in my own practice. The record label we record for, Warner Brothers, used to have, I think, maybe 5-6 years ago, had about over 600 employees. It's now down to under 400 employees. It's just that's a fact of life. The consolidation, the retrenchment, the big six, when we were kind of coming along, is now the big four, and it may very well be knocking on the door to the big three if Warner and EMI do end up merging, which is certainly a possibility. So, observing the landscape of the music industry in its various components, I would sort of diagnose the description and the health of them as follows. Traditional record labels, the words that might come to mind, play word association: struggling, embattled, hurting badly with revenues down, CD shipments down, some inconclusive signs of marketplace traction with the legal download services. Overall, a shrinkage of their business due in varying estimations to the physical and digital piracy eating into what's traditionally been the fatted calf of their profits, CD sales. And I love your PowerPoint because I was actually going to equate it to a leaky ship, and you had a leaky bathtub or colander. But that's, the fact is, the record companies right now are in a position where they have forever been able to batch together these things called albums, where if somebody hears a song that they really like, they go out and they have this transaction they buy a piece of plastic for somewhere around 15 bucks, maybe less, maybe more. And that's less and less the kind of transaction that goes on. So they've got to figure out how do they transition into a place where services, convenience are what people seem to be willing to pay for, and less about the physical product. And they haven't really figured it out yet. They're certainly trying everything. They're certainly trying a lot of different approaches and a lot of different possibilities. So traditional record labels, consumers. There's probably never been a better time to be a music lover. More music than ever, more ways to discover it, thanks largely to the promotional and distributional capabilities of the internet. Legal services, illegal services, internet radio, streaming media, podcasts, satellite radio. Probably never a better variety of music, a lot of it available anytime, anywhere, for free. Of course, how long this current free-for-all golden age is going to last is sort of anybody's guess. Sustainability feels to me like an open question in these early days of the digital Wild West. It's almost like a false economy. The things that everybody's enjoying right now, all this catalog, all this was done under a copyright regime where there was this essential transaction where a piece of plastic was sold, whichever the format was, and in return, the consumer got to listen to the music, got to own the music, got to play it. And as this basic equation is threatened, the question comes up to me: who is going to invest in the making of new music? For musicians, it's certainly a mixed situation. A lot of lowered expectations given the dire straits of the traditional labels, not as many artists getting signed, not as much investment going on for obvious reasons, but more and more options for getting the music out themselves. I'm sure a lot of you probably know, clap your hands, say yeah, they're the kind of poster child for doing it yourself. Certainly in England, the biggest act in England right now is an indie band, Arctic Monkeys. So the possibility of truly independent, do-it-yourself kind of approaches is probably better than it ever has been. But for musicians, the question kind of remains to me, if funding from the major labels dries up, what is going to replace it? The marketplace, Apple iTunes, MTV. There is this sort of phenomenon in the last decade or so that so many people making money off music are not the people actually creating the music or investing in the music. MTV doesn't pay for videos. Never have. That's their business model. They get it for free for promotional consideration and by playing the videos, which I guess they still do, and certainly some other video channels do. So I've kind of broken down a few questions that I think are worth looking at in terms of what musicians can expect as they move forward into this brave new world. What are consumers willing to pay for? We know that the value of music can be as low as free, off of songs emailed from a friend or to a friend, or downloaded from various internet sources. If they're really lucky, the record companies, they get rid of that problem. Let's put piracy to the side and say that piracy goes away and it's no longer a problem or a concern. But now we're up to sort of the 99-cent level, which is what it seems that music is worth now on a per-song basis. So instead of having an investment in music that leads to a $15 transaction, it's sort of like the top-line transaction you're really going to get to in the brave new world is going to be 99 cents, or if it includes some video content, maybe $1.99 on the iTunes store. So what are consumers willing to pay for? What do they value? It becomes pretty clear to me that what consumers seem to be most interested in is service and convenience. They seem to be willing to pay for ticket clubs, exclusive fan club access, ringtones that are tied to a certain kind of phone, extensions of their own personal brand. That seems to be what the kind of marketing strategies, and that seems to be where record companies are trying to head. Now, I also thought in Steve's presentation, he made a really good point that record companies have traditionally had a pretty bad deal with artists. And what I mean by that is the record company invests money in an artist, helps an artist become Green Day, at some point in their career, either early or most recently. And the minute that happens, the artist goes off and goes on tours, perhaps does endorsements, has all kinds of income streams, merchandise, et cetera, that the record company has absolutely nothing to do with. That's just the way the business model's been set up. And during the 80s, when lots and lots of CDs were selling because people were going back and replacing all their album collections with the newest format, in the 90s that continued, there was this double-digit growth that was common and that everybody got used to. And nowadays, Nowadays, it's looking more and more like that doesn't work anymore, because I used the Green Day as an example. It could be any other. It could be clap your hands, say yeah. It seems to me like where this is heading is either one of two things is going to happen. Record companies are going to figure out that they've got to participate, and they're trying, believe me, whether they're trying at the top line, sort of Korn, Robbie Williams type deals, or small baby band deals. They're trying to insinuate themselves more into the overall artistic creation process, so that if there's going to be an upside in an artist's career, the record company is going to participate in that. That seems like one way that this is heading. But there's a lot of resistance to that. There's a lot of pushback. Don Passman, good lawyers in Los Angeles, Eric Greenspan, are not really going to just acquiesce to that going on. It's not like they can just say, well, we need some of your touring income now because, we're just not selling as many records, so we now need to participate in your merchandise and your touring. But they're trying. They're certainly trying to participate more in the overall upside of an artist's career. Or I think another possibility is that management companies are going to start looking a lot more like record companies. Management companies right now typically sign artists, and they invest their goodwill, they invest their hard work, they invest their name and their wherewithal to an artist, but they don't really put much money into an artist. And it seems to me, if you just kind of looked ahead a few years, what's likely going to happen is whoever it is that seeds an artist's career, whether it's a record company or whether it's a management company or some combination of the two, is going to somehow participate in the overall upside if and when that artist is successful. We know that the deck is generally stacked against success. We know that most artists don't. The statistics were pretty compelling, but most artists don't sell even an appreciable number of records at all. But for those artists that do, there is still this subsidization that has to go on in order to float all these different careers. I think what is pretty clear to me is record companies are in more and more of an untenable position in that they're fronting the money, floating the career, making the investment. I didn't realize it was over $6 million for a typical artist, but They're making the investment to make, discover, nurture, break talent. And when, lo and behold, that actually happens to a few of them, they're not even participating in lots of the income streams that artists have. So there are lots of, there are some pitfalls to that to me, in that I think there's a checks and balances that's kind of grown up over the years. About 30 years ago, you would hear stories of management companies that signed artists to across-the-board deals. That would include management deals, production deals for the production of master recordings, and publishing deals. That wasn't always a good result. A lot of misery ensued during that. It was not a good result because there weren't any checks and balances. One person had way too much power. But that seems to me like one of the ways it's heading. Another of the possibilities is that record companies are going to be participating more and more in some of the other ancillary activities that artists participate in. So I guess what I would leave with is the business that thrived on selling $15 CDs because people like one song, is it going to be able to survive on 99-cent downloads and ringtones? And I think that's a pretty tough row to hoe for the labels, which is why I think they're going to try to participate in other parts of the artist's income stream. But either way, musicians are going to learn new tricks of adapting and surviving. And meanwhile, record labels are scrambling to bundle together content surrounding hit songs to entice would-be buyers. Extra special DVDs, advance access to tickets and exclusive merchandise, ringtones, whatever they can think of, preferably not easily downloadable. So I'm going to stop right now until we get to the questions part of it and turn it over to Jim. Okay.
And as Monty Python would say, now for something completely different. My disclaimer, I'm just up here having fun. Don't believe anything I say. No, I'm not representing the views of my clients or my firm or anything like that. And I am an IP lawyer. And I believe in copyright, and I think it's wrong to download other people's copyrighted music without authorization. Having said that, I'm really at an unfair disadvantage. I, like Bertis, thought it was 50 minutes, so I've got slides that'll take me an hour, but I'll do it in 15 minutes somehow. And really unfair is, apart from the fact that I flew all night last night to get here from Silicon Valley, I got to disagree with Steve, who's a terrific person. He's a dookie squared. He's charming, funny, smart, and really good guy, and I got to disagree with him. I wish I had his slides, because basically I want to suggest something else from all of that and some of what Bertis said, although I think I agree with his conclusions, which is...
Say we don't kill kittens?
No, I'm saying, we'll get to that slide. I got one like that. We got one like that. No, what I'm suggesting is it shows a business model in trouble that is very convenient and easy to blame peer-to-peer piracy for woes that have structural woes and have to do with changing audience tastes and a lot of other things I'll try and get into. But if the sound doesn't work here either, then the tech guy and the music guy loses. I just wanted to show you, A, I love music. B, even though I'm an NYU to the power of 3, I keep coming down here. I feel like a dookie. Plus, although I do give my senior MIT partner lots of grief because he's a Duke, and I say, you know, that lawyer we had this summer was really good even though she was from Duke. But I really love music, and so don't get the wrong idea from this. But I am going to take a little different viewpoint. So look at the big picture. The fact of the matter is, that I can't get the slides to advance, that music has only been a physical product for a very short span of human existence. For some 99.9999% of the time that music was first heard and been heard, it's a service. There's nothing written that came down from the mount that you have to have music on a piece of polycarbonate that costs you 15 cents to make and you charge $15, as we heard. That was a great model, worked terrifically, really wonderful. But I'm suggesting that times are changing and perhaps there's a business model issue here. And so, you know, it was Thomas Edison who actually sort of triggered this thing. He wasn't, by the way, this is my Grokster piece, and we can talk about that hopefully during the panel. Edison didn't start out to invent something to record music on. It was because he didn't like people sending letters, and we were going to do away with letters with this nice little plastic tube. Of course, it took the internet to do that, somewhat. And was a licensee RCA who figured out you could put music on these things. So this is, you know, something that's actually relatively new in human existence, and we all sort of think of it because all of us grew up with that model. So new technology, this isn't new. This is not a new experience for the content industry. This is Fred von Lohman's slides you've probably seen, to give credit where credit's due. Anyone know what, not this panel, anyone know what that was? One of the first things that scared the music industry at the time? Yeah, player piano, exactly right.
Hey, Abbott.
Yes, Costello?
Are you the manager of this baseball team?
Yes.
Who's on first?
That's right.
I mean, the fellow's name.
Who?
The guy on first.
Who?
The fellow on first base.
Who was on first?
What are you asking me for?
The NAB was started, National Association of Broadcasters, was started because the music industry went up on the hill saying those devils in the radio business are stealing our music and putting it out there for free. Now, I have some sympathy for Steve's position that they're not getting performance rights. I can't say that too loudly, I'll get in deep trouble. But I have some sympathy. If they want to withhold the music from the radio stations because they're not getting paid, they ought to do that. But here's a question. Remember the question Steve had? How much was Clear Channel paid by agents of the music industry to play songs in 2004? $300 million. I mean, the music money's been flowing the other way to get music paid. So I do have sympathy, but I don't quite understand it. But that's a piece of the business model issue. Steve's writing furiously. We're going to have fun in the panel. A lot of fun. Then one I'm intimately familiar with, which I could spend 15 minutes on alone, is the digital audio tape recorder, which was the subject of the Audio Home Recording Act. Great, successful product. You all have one, don't you, in your home? Then after that, the MP3 player, which we haven't yet had legislative action, but a court hearing that related, a court case that related to it. And finally, I did fail on it. I had some sound there that didn't come. The digital audio radio, as Steve alluded to. And again, I'm not attacking what they're saying. I am attacking, and I will attack the legislation because it requires technology to be changed. iPods paid $0. How much do theater owners get when they play? How much do they get when they play a movie? I mean, the fact of the matter is that there's this issue. We do so well in the IT business because of content. Well, if there were no DVD players or DVD-ROM drives, how many DVDs would be sold? And we tried. We really tried. These dates are interesting that were up on the charts because there's some interesting dates here. In 1996-97, we formed the Copy Protection Technical Working Group. It wasn't just Gary Shapiro and Jack Flendy, by the way, to tackle the issue of protecting DVDs, which, man, DVDs are badly broken, but somehow they sold $25 billion. Sold and rented $25 billion. We invited the record industry into that organization to talk. This is the wrong word. Boycott's wrong. It just said, no, thank you. I should have put that. Sorry, Steve. So in 1998, we heard these dates. Things began to become popular. So what happened is the record industry started looking for a solution to deal with that. And they came up with the Secure Digital Music Initiative. Again, I could spend 15 minutes on that, but we kind of missed the signal, the IT industry. We thought they wanted to get online in 1998. IBM had a solution we were presenting to them, but instead what they really were after was protecting the CDs. We had these conflicting industry agendas, and here's the result. Oh, here's a quiz too. Anyone can name the nation for which this national anthem, I was trying not to use copyrighted music. It's Acacia. I don't even know where Acacia is. But in any event, this was a SDMI compliant player. And it's wonderful. It looks like something that Rube Goldberg designed and Escher drew. But was this all a King Canute solution? I mean, the fact of the matter, the sad fact of the matter, or happy fact of the matter, depending where you are in Bertis' chart there, is that CDs are distributed totally unprotected. I mean, basically what we said is that, we wanted digital distribution. We could do it protected. We could do all that. But with respect to CDs, which was more the focus of if I can get this to advance. Is there some reason I can't advance it? There we go. We all agree that DRM's useful. Now, what it's useful for, we can have a debate, but it is useful. But we said, with respect to the CD format, game over. You can't protect it. There's no way. It's done. So the Sony Electronics, being a good Sony corporate citizen, did an SDMI compliant player, and it sold about, I think it was one of those 58% that sold 100. And SDMI died. And what happened, as we've heard, is the increasing popularity of MP3 players and MP3 music and people doing the wrong thing. But I suggest that at the same time there was a disarray in the music industry, that those charts just demonstrate that there's a problem in the business model. There were changing tastes. You could take that chart saying that there are less top hits being sold. You could extend that back to 1978 when they did Diamond. How many Diamond albums have there been, Steve?
I don't know.
I think 0. Which was established in 1978 because there was this upward trend. But people's tastes have been changing. Look at television. My God, there are 300 channels. There's a whole bunch. And yes, the internet's a problem there. I agree, because it's exposed people to a tremendous amount of different music. Plus, in addition to that, really challenging competition from other formats. I spent too much. My first job was in the music business. I actually do have a Sid Bernstein signed pass for the last Beatles performance. I worked in it, so I can't tell the difference. But I take Steve's word that HD's a threat, and they ought to have something there. So I missed. Well, we'll do it again. I'm sorry. Edgar Bronfman had a great quote. We'll get to. So it is under siege. I agree. The question is, what's the threat? By the way, physical piracy is a real problem. I have this on chart, but I want to state that. I mean, my client, Microsoft, loses more to physical piracy than the entire physical piracy losses of the record industry. Oh, wait, there is one legitimate copy of Windows XP in China. I think it's the one they use to make all the rest. But, so we talked about the top, this top percent as a scale. That could mean something different than piracy. It could mean people's tastes are changing. And the numbers, are we running out of juice there? The numbers you saw were numbers shipped, not sold, which is an interesting issue. Nielsen SoundScan, which scans CDs at the point of sales, has some different numbers, and they say music sales are growing. I don't know which is accurate, because there are little white lies, big bold lies, and then statistics. So I've never been able to see the real numbers. I don't think anyone has. Sales of digital singles are going like crazy, as we've seen. It is at that 99-cent price rather than $15 to get the one song you might like. And so what are they losing sales to? Physical piracy, absolutely. I agree that that's a lost sale. But DVDs went in the same period from 0 to $25 billion in sales and rental. And VHS was only like at its peak about 10. So it's coming from someplace. It's entertainment dollars. Also, game software has gone crazy, as well as ringtones, as we've heard, instant messages. My kids, I bought several extra phone lines because I thought, all I hear from their rooms is bong, bong. By the way, I told them I'd break their arms if they downloaded anything illegally, and I gave them iTunes cards and had them on iTunes. And there are, oh, you got that, huh? There are other artists, this is all anecdotal, that, yes, the decline has been less in the bottom part, but they're not selling that much per artist. And the growth of independent artists. We don't have those numbers, it's just anecdotal. And the P2P studies, there's a tremendous amount of conflict on P2P. Again, it's bad. The question isn't whether it's good. We shouldn't encourage it, we should discourage it. The question is, what do we do? 3 minutes, uh-oh. So the customer is always right, is my answer to this, which is sort of where I thought Bertis was going, and I think so. He can disagree with me later. I'm eating up time just trying to change the slides. Can you do it from there? Yes. People believed CD prices were too high, and this is a poll. Why don't you do? Well, I'm doing this. Do the thing. 71% considered 99 cents a fair price. Click. 92%, according to this poll, and polls are. I think this is wrong, but polls are polls, and everyone relies on different polls. But this one said 92% said they never illegally downloaded songs.
That was a 65 and over group.
Yeah, it was 65 and over. A Rolling Stone 65-year-old, this I gotta see. 80% consider it stealing. 58% believe music's getting worse. I don't like that number. And includes, but here's the 65-year-olds. This poll included 49% of 18 to 34-year-olds, a top demographic. And there were, and I think some of the things you saw in the decline, like 600 to 400, a third of the artists were cut out between 1998 and 2001, before there was as much impact. You know, and prices in that same period went up 10.5%. In my business, my client's business, if you cut production and raise prices, tend to sell less. Funny thing about that. Mark Cuban, who's really sort of a crazy man, has, I'm afraid I stole some of this theory from him, that the business model is
There shouldn't be any surprise that CD sales are
Yeah,
dropping.
fewer products, fewer marketing dollars to support those products, and fewer square feet to sell those products usually means you're going to have lower sales.
Yeah, I mean, it's just sort of some intuitive stuff. Now, RIA and fair use. We talked about fair use. I got to take just a minute or two longer, and hopefully Steve can straighten this out for me. In the Grokster case, Don Verrilli said, the record companies, my clients, have said for some time now, and it's been on their website for some time now, that it's perfectly lawful to take a CD that you've purchased, uploaded it onto your computer, and put it onto your iPod. Verbatim quote from his Supreme Court oral argument. In a document filed, I believe was this week, by the RA's lawyers, outside counsel representing a bunch of content people, but addressing this specifically in the triennial review of the DMCA exemptions, nor does the fact that permission to make a copy in particular circumstances is often or even routinely granted necessarily establishes that the copying is a fair use when the copyright owner withholds the authorization. In this regard, the statement attributed to counsel for copyright owners in the MGM Grokster case is simply a statement about authorization, not about fair use. Interesting. On the RIA's website, it says, if you choose to take your own CDs and make copies for yourself on your computer or portable music player, that's great. It's your music, and we want you to enjoy it at home, at work, in the car, or on the jogging trail. So either, you know, you could say it's authorization, which means don't copy, don't do this, don't rip independent labels, only the labels that belong to the RIA. I don't know. I hope Steve can help me out on that. They're either, you know, it's interesting, Bertis and I are dog lovers, so I think that maybe they've got the killing kittens is wrong. Maybe it should be puppies, because neither Grokster nor the lawsuits seem to be stemming a tide that I think's bad. I really do. So file sharing is up in the United States since January by 98%. This is bad stuff. This is big champagne, and you may have different numbers than that. And wider access to broadband has meant more P2P. Let me get to my conclusion. I know I quit. So is the labels problem P2P or a business model in a rapidly changing market? Is that the problem? Piracy is always going to be around. There is nothing we can do to stop it. Hopefully, we can do lots to ameliorate it. And a lots is physical piracy. I mean, I walk down Broadway in New York, and there are people offering me, you know, obviously ripped off CDs. P2P is rising, but sales seem to be up. Steve has different numbers. And the effects of P2P can be viewed from both sides as to whether it's hurting the business or it's a convenient scapegoat. But stealing isn't right. But here's the key, and one of the, I forget your name, saying this to me at lunch, was the point is buying music should be easier than stealing it. And we're getting there. I really am excited about some of the stuff that's happening now. It's late. It's 8 years too late almost. But they're doing things. iTunes is the first step. There's a lot on that list, and I hope to see more. But also I think that Bertis is right, that it's going to be more services. By the way, Apple's almost to 1 billion served. Go to iTunes.com, and you can see they're rotating through the numbers. It's a struggle. We're in a transition. And, you know, I think that the problem is that there's this analog peak that they're coming down off of. That was a great thing. Well, it lasted, selling physical products. I believe there's a digital peak, which involves a lot of services, a lot of stuff, but there's no straight line, unfortunately. And I would hate to see the record industry go down too far. I wish them success in the online ventures, and some of my clients are doing it, so of course I wish them success. But I do seriously, because I don't want my kids growing up thinking it's right to take copyrighted product. But I think one has to be careful that you can get too focused on this issue of peer-to-peer piracy and not focus on what Bertis was suggesting, finding things that are going to make up for the fact people's tastes have changed, that the model of promoting 3% or 5% of your artists is not necessarily the way to do it when people want more broader changes. And I think I have a concluding sound piece, but it may not work. No. I don't know why. Bronfman, did you do that Edgar doesn't want to? My final point, which we can maybe talk about the panel, is I just sort of have a viral reaction to legislation that tells us how to build IT equipment or consumer electronics equipment to protect people's intellectual property. Unless that should be bilateral in a marketplace. By the way, we do that. We do build protections in the machines, but they're negotiated bilateral business deals in the marketplace. And hopefully we'll have a little exchange, and Steve can tell me why I'm completely all wet about that. But thank you. Sorry I ran over a minute or two.
Oh, no, I'm sure you'll agree with everything I'm going to say, seriously. Actually, I have to say I'm somewhat surprised that I'm not disagreeing more, actually, with what everyone said before, including Steve, so this will be interesting. I have to say, though, I am interested, for the panel discussion later, I'll just flag this right now, whether you can articulate why it is not a fair use to take your music collection that you've legitimately bought and put it on your iPod. So if there's a case to be made why that's not fair use, I would love to hear you, we're in a law school, make the legal case for it. So I'm going to put that out there right now. That is one thing you can write down. Tell me and everyone else in the world why we're all criminals. So I'm Jason Schultz. I'm a staff attorney at the Electronic Frontier Foundation. For those of you who don't know, EFF is a nonprofit legal foundation based in San Francisco. I am a Duke grad from '93, go Blue Devils. We focus on a number of different areas, privacy, free speech, but more and more in the recent years, we have focused on the intersection of intellectual property with technological innovation. And one of the things that we focus on is how is this affecting the public interest, and particularly how is this affecting consumers, music fans, and also innovators, people who want to use technology in any way. And much like Jim and everyone else, I'll come straight out and say I'm an intellectual property lawyer, and this is not about destroying intellectual property. This is about trying to find a balance. And to be realistic and honest, we have a very different view of what a balance is than, say, Steve or some of the other people, but it is striving for a balance. And if anyone has questions about what we're for in those arenas, I'm more than happy to answer them, where I think strong copyright and patent protection and all those things have a really good role to play. So I'm going to talk a little bit about perhaps this different business model that we're talking about today. So let's see if my magic works. Okay. So we've actually, a bunch of the stuff I'm going to talk about today, we've actually gone over. It's great, some of the earlier presentations, so I'll speed through it a little bit. But when you talk about copyright, you really have to think about not only content creators, but technological innovators. And we've already talked about some of the balances between them. But that it's really gone hand in hand since the Gutenberg printing press. That you have music, you have books, you have films, but you also have things like TiVo, PlayStations, iPods, and these all kind of work together, and that's part of the balance that I think is important. We can't leave one behind. So we enter into, through the great history that Jim talked about and a bunch of other things, this file sharing dilemma, right? So you've got lots of file sharing going on. You've got 12-year-old girls getting sort of caught in the middle. You do have artists who aren't getting paid, and that's another thing I want to emphasize is that we think that's a huge problem. Artists, record labels, rights holders need to get paid somehow, and we need to figure that out. It's not about everything for free, but it is about a balance. And here's my little, this isn't as good as Killing Kittens, I should have used that one, but someone did mock up a little RAA SWAT team there at the bottom right. In honesty, that's not what's happening, but that's how people, many people feel, right? They feel, especially the people who are being sued, whose identities are being subpoenaed, that there is a kind of paramilitary enforcement effort going on that doesn't feel right to a lot of people. They feel it's invasive and wrong, and there should be a better solution. All right, forget that. This was a picture of the Wayback Machine from that cartoon with Sherman, the dog. I don't know if any of you remember that. But if we go back, I want to take a brief little historical trip back. This is somewhat similar to Jim's thing about sort of how we've dealt with these problems in the past. This is a quote from 1906, which is similar to the piano player era that Jim was talking about. These talking machines are going to ruin the artistic development of music in this country, yada yada. And then I like the last quote, which is, the vocal cord will be eliminated by a process of evolution, as was the tale of man when he came from the ape. So, who is this prophet who's foretelling the future? Again, apparently none of my pictures are going to come through here. It's actually John Philip Sousa, and he was talking about the phonograph. So sort of one of the early great composers in America was very worried because he was a songwriter, and he was used to people performing his songs, and he thought, oh my God, here comes not only the player piano, but this phonograph. No one's going to sing anymore. It's going to destroy the industry. And as we know, it didn't destroy the industry, but it did radically change it. Okay, so fast forward to 1982. Here are a couple more quotes. Now these machines are advertised for only one purpose in life, their single mission. Their primary mission is to copy copyrighted materials that belong to other people. They're advertised that way. These are things that can make a grown man cry, right? All right, we're really not going to have any of my pictures. This is really depressing. Okay, so this is Jack Valenti versus the VCR, the Betamax. This is also, there's a famous quote from him, too, that he gave, which is that he equated the VCR to the American film producer as a Boston Strangler to a woman alone at home. And obviously, I'm an advocate, and as a lawyer, you learn to be an advocate and to use extreme examples to try and make your point. And, to give Jack credit, he probably actually didn't mean it that harshly. But, I think he was trying to express a viewpoint that this was kind of the end of a business model. And he was right in the sense that it evolved. The VCR actually and home rentals and tape sales became a huge industry for the movie industry. It actually ended up making more money than theatrical releases, and we've seen that legacy in the DVD market. And that things did change. It was a radical transformation. But it was a way in which balance was found between technology and copyright industries that make content. Okay, so here's another quote. Just imagine for 1 minute, television with no music, films with no music, radio with no music, just 24-hour news. Actually, we have that. You don't have to imagine it. Home stereos and car radios with no music. If you commute in the mornings, that's probably true. Parties, weddings, Broadway shows. With this activity, whatever he's talking about, of 85%, we're getting very, very close. So this is 1982. What horrible, dramatic activity is this? Again, no pictures. It's Quincy Jones talking about the dual tape recorders. He's saying that home taping off the radio is going to kill the music industry, that there won't be any more music for anything anymore because VCRs and tape cassettes, people aren't going to buy music anymore. They're just going to record it off of radio and other things, and the industry is going to go completely bottom up. And again, this is testimony. People are advocating. They're very, they tend to be prone to hyperbole, myself included. And but the point that he was making is actually one that we agree with, which was it was a radical change, right? All of a sudden, users are participating, right? Just like they were when they got a phonograph, just like they were when they had a VCR. They're participating in the music industry, in the content industry, and that radically changes everything. Okay, well, a couple of these showed up. That's good. I guess my point here is that you have a copyright theory, and we have copyright law, but as lawyers, you have to be aware of reality. And the reality is that copyright's evolution has depended on both innovation and user participation over the last 100 years. That as innovation has created new tools, users are going to use them. And to the extent that we can find a way for users to participate in the economy can actually grow and flourish and evolve. So users can, in fact, tape things off of TV. People can put things on their iPod. People can take digital photographs and upload them on the internet. People can listen to music and dance, when music's on a jukebox. They can have boom boxes where they go around doing unlicensed public performances all the time at parties and barbecues. But the reality is that we have found a way to make this work. We have always found a kind of compromise in copyright law that allows these kind of personal freedoms, this sort of user participation. It may involve a radical change, but it is an evolution. Okay, so what does a solution, to me, an ideal solution for peer-to-peer look like? Well, first and foremost, artists and rights holders get paid. And that's, again, what I wanted to emphasize is this is not about making things available for free, unless you mean free as in freedom. Because I do think freedom to use stuff is very important, but I don't mean free in terms of price. So that's number one, is we have to find a way to pay people. But two, I think users have to be able to participate. to the extent that you treat them only as boxes that you shove CDs into, or consumers who only buy things and take them home and don't do anything that's unauthorized, not only do I think you're living in a fictitious world, but I think you're missing out on a huge advantage. Word of mouth, community, user participation is a huge way. I mean, building a fan base, right? The way that we heard from Bertis, the way to get a great rock band going is to have a fan base, right? Figuring out how to get users involved in the economy of copyright is a key component. Innovation thrives, and sorry, Mom, and to all the law students here, but I think actually the fewer lawyers, the better is actually what the solution involves, and that's myself included. I would like to actually get more lawyers out of that game and leave it to the artists and the innovators as much as possible. And then finally, privacy, choice, and freedom. In that, I think a key component of how users have participated is when they don't have a big brother looking over their shoulder, when they have choices of the different devices or software or other things that they can use to play with the content they have, and a certain freedom, a certain amount of flexibility so that they're not constrained all the time. Okay, so good. Some images are showing up, which is good. So the music business solution 1.0 to the peer-to-peer dilemma has been lawsuits, right? So they sued Napster, they've sued Grokster, Morpheus, and Kazaa. They've also sued, how many is it, over 16,000? Close to that? 17,000? You can write that down too. Individuals for music downloading and uploading. And what this has done in a lot of ways is driven a lot of people to what's called the darknet. And that's sort of an ominous picture I found, where a lot of people are trying to stay underground. As we've seen, the numbers are still very high, but this has kind of made people less public about it, which is why I think when you see a survey that says 92% of people have never downloaded illegally, it's like if I called you up on the phone and I was anonymous and saying I'm taking a survey and said, how many of you have ever done drugs or stayed out late after curfew, or maybe in college did you drink when you were under 21, then you'd probably get similar responses, 92%. Oh, I never, ever, did any of these things. Mom, is this you? Okay, so what has been the reaction to this, which is that people have gone underground. And this is a picture of an iPod party. And there are a lot of these parties actually going on all over the country. And these are not hackers. These are not like computer savvy, coders. These are music fans, right? But what they do is they get together and they connect their hard drives and they say, oh, I have 10,000 songs. How many do you have? Oh, I have 25,000. And they're sharing songs. It's going on all the time. And one of the things that's going on with it is that they're not connected to the internet, so the RAA can't track them, right? This is at least the perception. And again, I'm not advocating this as something to do. I'm saying this is just reality. We have to deal with it. Users are participating in the music economy, in the content economy. And they found a convenient way to do this. Now, does Apple want this? No, they put the don't steal music thing on there. But people have figured out that this is a way that they can get music they want. And like I said, these are not sophisticated techno hackers. These are like college students, right? Just getting together, having a good time. Okay, so the Music Biz Solution 2.0. As was alluded to earlier, there's been a lot of attempts by music companies to put various software on music CDs and other things called digital rights management to constrain you to, you can't put music on an iPod, or you can only put it on so many computers, or if you try and do certain things, we'll catch you and restrict you and shut down your CD player. And so Sony BMG attempted to do this and ended up installing surreptitiously a program that was called a rootkit, which essentially made your computer vulnerable to various viruses and other things. That the response to this was 7 class action lawsuits, several attorney generals investigating, and recently an official from the Department of Homeland Security sternly warning the music industry not to use this kind of software because it's a security threat. So that didn't work. So what is the answer? All right, so this is a little cartoon that I like, not because I advocated, because I think it shows a certain mentality. I like the fact there's stolen music 2, and music I stole, right? So, but basically that this is sort of the users are getting fed up. They're trying to sort of joke about this, but there's a little bit of a pushback culture coming, right? So, and I like that line, the American copyright law is biased against citizens. In other words, there's sort of this feeling that users can't participate, that we're being pushed out, that we need to get in there somehow. And if there's no legal way to do it, we may do it illegally. But we are part of the process. So if we look at some of the internet business models for user participation, you see some interesting things. Google is actually a very user-driven business model. Your clicks, what you look at, what you find relevant, what you link to, drives many of their search results. eBay, obviously very user-driven. Even iTunes and the iPod, to the extent that you can stream your music and that you can load your MP3s. I mean, one of the reasons that Sony's MP3 player failed is because it didn't allow MP3s on there, didn't allow you to rip your CD collection. One of the reasons the iPod has been so successful is you could rip your CDs and put them on your iPod. Some of you might be familiar with these websites and companies. These are sort of called Web 2.0, which is kind of a catchy term right now. But again, they're all built heavily on user participation, right? So Flickr is a photo sharing site. If you go to it, you can see there are 2.3 million users who upload photos all the time. They have over 100 million photos. It's only 2 years old. And part of what happens is that here's a photo on Flickr. You can put it into sets. You can send it to different groups that people belong to. You can allow lots of comments. People can tag it with whatever they want. These are the other users coming to your site. User participation from communities, from other people who happen to run across what you're doing. It's very user involved. Okay, MySpace is only 3 years old, and yet it has 37 million users. It's the third most popular destination on the web. And we've already seen it being used by certain bands. Arctic Monkeys was mentioned. Much of the reason that they are popular in the UK has been attributed to their release of debuts on MySpace of sort of interacting with the community. 9 Inch Nails and The Darkness have also done that. Here's a sample site from MySpace. It's actually not that great. I mean, the UI is actually kind of bad. Like, it's hard to see exactly where everything is, but this is incredibly popular. And it's because the architecture lets you play your favorite music for people when they come there. It lets you get involved in a lot of ways. It's very user-focused. YouTube is a video service that's only 1 year old. And lots of people can upload videos. And then, again, you have this sort of user participation. There's actually, I like this, Pretty Girls Make Graves is having a video contest where you can make a video for them. It's a band. Any of you who saw the Chronic of Narnia rap from Saturday Night Live, one of the things that they did is they put it up under a Creative Commons license, which is a liberal copyright license, to allow sharing through YouTube. So you could send it everywhere in the world that you wanted and helped make it extremely popular. In fact, at the end of every YouTube video, it says, do you want to share this video, right? So they're very user-focused on user participation. This is from the Chronic of Narnia. It's had over 5 million views. You can see the links are coming from MySpace and other sites, but it also gives you an embedded player and a video URL link. So if you have a blog or some other website, you can actually take the video player and embed it in your web page so you can become part of this meme, part of sending it around, right? It has links, groups, people have playlists. It's very user-focused. I'm going to speed through this last part to get to the end, but any of you know about fan fiction? There are all these people out there who write their own stories about Anakin and various other people in Star Wars. There's also Back to the Future, which is sort of a funny little parody where it takes Marty McFly and Dr. Brown from the Back to the Future movie and sort of recasts them in this closeted gay romance. It's kind of... But I mean, it's this idea that users want to participate, right? They want to get involved with the characters, and this can actually help spur loyalty. I mean, there's incredible amounts of Harry Potter fan fiction out there, and I would suggest that most of those people writing it probably own all the books, saw the movies, maybe even have the DVDs and the chess set or whatever, right? Okay, there's podcasting, which was mentioned earlier, and I'll let you read a couple of these panels about sort of the silly things people are podcasting about. One of them on the right says, Timmy unveils his 6-hour epic, The Sounds of My Sea Monkeys. The guy says, I can't hear anything. He says, that's because they're meditating. And there's one on miming here. I don't know. Anyway, but I mean, the thing is that the whole podcast, pickup and evolution, I think, has come from the fact that users finally got their hands on stuff they can participate in. They want to participate. And lots of them use copyrighted works that aren't theirs. Lots of them read books. There's a great podcast, actually. It's one of my favorite, of a father and his 10-year-old son reading Harry Potter, right? I mean, they didn't get a license for that. And we can talk about the copyright issues, but the point is they're not criminals. They just want to be part of it, right? So I just want to make this thing that, file sharing, good or bad, illegal or illegal, it is about user participation in a big way. People ripping their CDs or recording stuff off of analog radio, they're tagging it, they're voting, they're downloading. A lot of it is about user participation and could be more. Lawsuits, on the other hand, are not. Lawsuits are actually completely against user participation. And in fact, they're trying to get you to stop participating, right? Stop participating. Don't be a user. Again, it's not that there aren't rights under the law for this, but as a social phenomenon, in terms of looking for a solution, I just don't think it involves this element at all, and I don't see any end in sight. If this is our solution, it's going to go on forever. It's just going to become a constant part of our culture and society, and that's not something I'm very excited about. That's not a future I want. I don't want a future where, in 3 years, every 3 years, 17,000 people get sued. That is not to me a good copyright world. So I don't even have to talk about the slide very much because Jim and a bunch of other people mentioned that there are different kinds of licensing schemes that do are user-centric in the sense that they issue licenses either voluntarily, collectively, like ASCAP BMI for radio, or compulsory, where if you have the smallest little band in the world, you can do your cover song of the latest Madonna album or whatever, because you can, in fact, if you follow the rules, get a license and she can't stop you, right? You can go to a place and if you have a band, you can go to a club if they're covered by the performance licenses and play your songs that you want to do with your cover songs. Like, there are ways in which people can set up their own webcasting on the internet. There are ways in which users can get involved, and we've figured out legal answers to that problem. They're not perfect, they never are, but they get us there. It's a balance. So, last few slides. When you're looking at user-centric models for music and potential solutions to peer-to-peer, there are actually a bunch of these out there, and these are just some ideas that we have that have been discussed ad nauseum. It's not like any of these are new, and Steve isn't hearing them for the first time. But they are out there, and they do involve user participation. Users can get involved in supporting artists, right? Here's one that EFF specifically has endorsed, which is voluntary collective license, where users do get individual licenses, or they get them through their institutions. So like Duke could buy licenses for everyone here to peer-to-peer file sharing, or an ISP could offer it to their clients, or other kinds of software companies could sell software where it comes with a license involved. But the user participation part of this really is who gets the money. So if everyone, say 60 million people do file sharing, and say half of those people sign up for a $5 a month license, right? So that's 30 times 5, it's $150 million a month, right? Where does that money go? Well, similar to some of the other things like webcasting and radio and whatnot, there can be sampling systems, right? That can be anonymous, so you don't have your name associated with it. But like, what's on your playlist? What are you listening to? And users can get involved in the sense that the more they listen to their favorite bands, the more they promote their favorite bands, the more they maybe even share music with their friends, right? That iPod party can become a way where if your music becomes super popular, you get a bigger chunk of the pie, right? There are ways in which this can work. None of these ways are perfect. They all have flaws, but they're about user participation, making them part of the solution instead of part of the problem. So that's basically what I said. Lawyer participation discouraged. And if you want more information, you can just Google. We have a white paper. It's also outside, and you can check out our website. So thank you very much.
Thank you very much for those wonderful presentations. That sure set up for a very exciting panel discussion. So we're going to let Jim and Steve duke it out. Duke against NYU, so we'll be taking bets. So anyway, seriously though, we are going to take a 10-minute break and then be back about 10 after 4 for the panel discussion. Thank you.